Hello and welcome to Win Without Law School. I'm Arizona lawyer Julie Lebenz. Today, we are going to talk about the simplified child support modification procedure. So this is if you're already divorced or legally separated, or you already have child custody papers established if you were never married, but you have a child in common. So you already have an underlying order for child support and you want to modify it. There's two ways to do it. There's the standard way, and then there's the simplified way. And so that's what we're going to cover today is how to qualify for and then how to pursue the simplified child support modification procedure. In part one today, we will talk about how to determine whether or not you qualify to use the simplified child support modification procedure. In part two, we'll talk about the forms to use to pursue the simplified procedure. Part three, we'll talk about how to serve the forms. Part four, we'll talk about how the simplified petition is contested. So if you've been served with the petition, we'll talk about how to contest it. Also, if you're the one serving it, we'll talk about what you can expect if you are anticipating a contest. And then also in the final part, we'll talk about what happens if the petition is not contested. All right, let's look at an overview of the simplified procedure. The first step is to file a petition to modify child support using the simplified procedure, plus the other required papers. Once those are filed, you serve the petition and the papers on your co-parent. Once your co-parent is served, if you serve them in Arizona, then they have 20 days to request a hearing. If you serve them outside of Arizona, then they have 30 days from the date of service to request a hearing. If your co-parent does not file a request for a hearing, then the judge will review your petition and the other papers you filed. And based on your filing, the judge will either grant the relief you requested in your petition, or the court will set a hearing. So if your papers don't have sufficient information in the eyes of the judge, then the judge could set a hearing to seek additional evidence. If your co-parent requests a hearing, then the court will set a hearing. So this is the overall procedure. We're going to talk about these forms and all of this in more detail, but just keep in mind this procedure. You're going to file. Once you file, then you need to serve. Once you serve, then you wait to see if the other side is going to request a hearing or not. And if they don't request a hearing, then the judge either grants the petition or sets a hearing. And if they do request a hearing, your co-parent, then the court would set a hearing. So that's the overall simplified procedure. How do you know if you qualify for this procedure? Let's talk about that. Number one, if there is a 15% difference between the current amount of child support and what you're requesting the new amount be, and we're going to talk about how to do this calculation. But if there's a 15% difference between the current amount and what you want it changed to, you would qualify for this simplified procedure. If you're seeking to assign or alter the responsibility to provide medical insurance for a child, so if in your underlying order, neither parent was ordered to provide medical insurance for the child, or if you were ordered to provide the medical insurance and you want that changed to your co-parent or vice versa, you would qualify for this simplified procedure. Or if one of your children became an adult, so one of your children has aged out, then you could seek to use this this simplified child support modification procedure to modify the child support so that your oldest child is no longer considered in the calculation and just your minor children are part of the calculation. So these are the ways to qualify: a 15% difference between the old amount and what you want the new amount to be. If you're wanting to change or assign responsibility for medical insurance for your children, or if one of your children became an adult. How do you calculate the percentage difference? So what you're going to do is first you're going to calculate the difference between the current amount and the amount you want it changed to, then you're going to divide the difference by the current amount, and you're going to convert that to a percentage and see if it's 15% or not, more than 15% or not. So here's an example. If your current amount is $950, and then you run a new calculator based on your current income, and it shows that child support should be $550, then number one, your difference between the old amount and the new amount that you want is $400. So now you take the $400, that difference, and you divide it by the current amount, by the $950, and you get this number. And then you convert that to a percentage by moving the decimal point to the right 2 times. And that's going to get you a 42% difference. So that's obviously more than 15%. So take your current amount, subtract it from the amount, what's the difference between that amount and what you want it to be? Divide that by the current amount and convert that to a percentage and see if you're over 15%. Now let's talk about the forms to use for the simplified child support modification procedure. First of all, you've got your petition. Then there's another form for request for hearing. Now, this request for hearing form, this is just a form you're going to serve on your co-parent, but you really don't need to fill it out other than, putting your case name and information on it. But this is the form they would use to request a hearing. So you do provide them with that form as part of the paperwork that you file with the court and serve. You'll want to file your proposed child support worksheet. So the amount you want child support changed to, the worksheet that supports that amount, you're going to e-file that. And also, you want to attach to that documentation supporting the incomes used in the calculator or explaining why income should be attributed. Now, for more on income attribution, go to the child support case strategy videos. In essence, income attribution is when somebody is unemployed or underemployed, and you assign an income to them that is a reasonable income that they're capable of making. You also need to file an affidavit of financial information and a proposed child support order. Now, we're going to go over all of these forms, but these are the 5 forms that you'll need to complete an e-file to initiate a simplified child support modification case. All right, let's look at the petition to modify child support using the simplified procedure. So this is Form 1. Here is what the Maricopa County proposed form looks like. Now, if you are not in Maricopa County, you can just take this form and cross out or white out Maricopa and write in the name of your county. So feel free to do that. Also, you can look on your county Superior Court's website and see if they have forms that you can use, and you could use those. But if they don't have those forms, or if it's just easier to grab this form because it's in the members area, realize you can tailor it to the county you're in. So first you'll fill out the case caption. So obviously fill out this information about the filing party, name, address, contact information, representing self, and then the name of the petitioning party in the original case. So this is going to follow the caption on your underlying order or decree. So party A, party B, those are never going to change. The name of the petitioner and the respondent is always going to be the same as it was in the initial case that was open to start your family law case. So your initial divorce pleading or your initial custody establishment pleading, however the parties were in that pleading, it's going to be the same here. Fill in your case number. Now, this is a notice to the other side saying, hey, look, pay attention to this because this could result in child support being changed if you don't request a hearing. I mean, it could also result in child support being changed if you request a hearing, but it could just be changed without hearing from the other side unless a hearing is requested. So this is just giving the other side notice of that. So now you're going to look at this. Here you've got party A, and it looks like this should be an A, but it's a B, but party A, party B, and then C. So Are you party A or party B? Who's asking for the modification? So you'll just check that box. And then this is a reference to your underlying order. Your underlying order was issued on what month, day, and year, and who was the court that issued it? Is it in the same county you're filing in? And then in your current child support order, explain which party is responsible for providing medical insurance, or if neither party was ordered. So just fill that out and then go to page 2. You can put your case number up here. The child support order currently in effect requires which party, A or B, to make payments of the amount per month payable on which day of the month. So this is going to indicate what the current support order is, who pays it, how much, and when is it due. Attached is a child support worksheet. According to the worksheet, so this is the worksheet you've created that you want the court to adopt. This is with your new child support amount. According to the worksheet, child support should be, and write in the amount that your new child support worksheet says the new child support amount should be. The following calculations show that the new amount varies from the current amount of court-ordered support by 15% or more. So this is the same calculation we just went through on the earlier slides. So you're going to get the difference between the amount currently ordered and the amount requested, the amount currently ordered. You're going to divide by that, and then you get the percentage difference. Is the Department of Economic Security or the Division of Child Support Enforcement providing services to at least one of the parties? Check whichever box applies in your case. Number 7, are there any other court-ordered payments included in the current order of assignment and include the date of the most recent order of assignment? In other words, does your co-parent also owe you spousal maintenance or any child support arrears payments that have been ordered in an order of assignment? If so, include that here. And now you're going to get into the relief that you want the court to order. So you're requesting that child support be changed to what amount and what party to pay it. And then if you're requesting any changes to which parent provides medical insurance, you want to include that here. If you want any changes to the division of uncovered medical expenses for your children, you'd put that down here. If this matter goes to a hearing, I further request that costs and fees incurred in bringing this action be ordered to be paid by the opposing party. So that's standard language in the document. And then this is where you would sign this pleading in front of a notary. You could also sign it in front of a court clerk. Put your case number up here, and that completes your petition. Now let's look at Form 2. This is the request for hearing form. You don't need to fill this out. You just need to file this and serve this form on the other side. It's 1 page. For your co-parent, if they want to contest your requested child support modification, this is how they would request a hearing. They'd fill out this document and then file it with the court and provide you with a copy. All right, now Form 3 that you need to file to initiate your child support modification case is a child support worksheet with your proposed new amount of child support, along with documentation supporting the incomes used in the calculator or explaining why income should be attributed. So here's an example of a child support worksheet. Obviously, this one is blank. For thorough instructions on how to complete this worksheet and for access to the worksheet, go to the videos about creating a child support case strategy in the establishment or divorce sections of Win Without Law School, and you'll find a video exactly on point along with the material, the worksheet itself. So you'll have this filled out, and down here, it'll have the new amount of child support, and you're going to need to attach that to your petition or have it as a separate filing. And then you may be wondering, well, look, what type of document should I use to support the incomes in my proposed calculator? Well, you could use pay stubs. So your pay stub, if you have a copy of your co-parent's pay stub, you could use both of those to substantiate current incomes. Tax returns, you could use those. Keep in mind with tax returns that gross income for tax purposes and adjusted gross income for tax purposes is not the same as how gross income is defined for child support purposes. However, we're talking about documents you could potentially use to show income, and tax returns are one of those, but keep that in mind that tax returns may or may not be the best documents to use. What if you and your co-parent have exchanged emails and texts about your co-parent's income and they say, oh yeah, I'm making $20 an hour right now, or I got a job offer for that? You could attach the email, a copy of the email or text showing they are admitting to earning a certain amount of income. Also, you could utilize something like salary.com. What is your co-parent's job? What's the standard rate of pay? And then show that. This would be like an income attribution. So if you're saying, hey, look, I'm using salary.com to show that they're not currently making this, but this is the type of job they're qualified for and what they could be making. Or you could be, and that would be an income attribution, or you could say, look, I don't know what their exact income is right now, but I know they're working this job and this is what this type of job pays. And so then you would also be attributing income because it would be a guess as to what their actual income is. But that's another route to go down. Now, often you'll be making the request to modify based on a change in your income. So that's where you can attach documents showing the change in your income, and then you could use the same income that was used for your co-parent in the underlying child support worksheet. That would be one option where you would just have to show documents related to your income versus both sides. You'll also need to complete and file an affidavit of financial information. Now, this form is 12 pages, so we'll go through this. This is the first page. Obviously, fill out the caption. You're going to sign it once you've completed it. This is page 2. In this box at the top, this is asking you to provide the following information about your income: all sources of income, attaching your most recent pay stubs, attaching copies of your tax returns for the last 3 years. So you'll need to explain yes or no whether you're providing these. Now, understand that you don't necessarily have to attach all of these documents because, attaching sources of income, pay stubs, and tax returns, which can be really long, W-2s, 1099s, that can make the document like 50 to 100 pages. So you don't have to attach them here, and instead you could just disclose them to the other side and not file them with the court. So you could mark no for all these and write in a little note saying these documents are being disclosed. Or just if you're not just sharing them at all, you can explain that as well. But I did want to give that option. Not everybody wants to file all these types of documents with the court. And so that's an option to still exchange this information without having to file it with the court, and that would be through disclosure. Okay, now below the box is general information. You'll fill that out. Part E, this is the names of children common to the parties and their dates of birth. F is the name, date of birth, relationship to you, and gross monthly income for anybody who lives with you. Subsection G, this is about any other person for whom you contribute support, any attorney's fees you've paid in this particular case. And then it gets into your employer information. It also has you list your gross income for the last 3 years, your gross income for this year, year to date. So a lot of employment and income information on this page. You'll also include your education background, and then you'll get into the specific details about your current gross monthly income. Attach 2 of your most recent pay stubs or disclose them. For this type of pleading where you're asking the court to modify using the simplified procedure, I recommend that you attach copies of your 2 most recent pay stubs. And then indicate if there's any expenses that your employer is paying on your behalf, indicate how much they're paying for those expenses on your behalf per month. Add up all of those amounts. And then for part 5, if you're self-employed, you'll include that information. So if you have your own business, you would fill out Part 5. Part 6. Now, this is a schedule of monthly expenses for children. So fill out information about health insurance, unreimbursed medical and dental expenses, childcare costs, employer pre-tax program, court-ordered child support. So just fill these sections out as they apply in your case. Court-ordered spousal maintenance, extraordinary expenses. So fill that out. And then we get to this final part, Part 7 and 8. And you only fill out 7 and 8 if, okay, let's see, there's an adjustment or deviation from the child support amount. And in the petition, a request for fees and costs was made. So you will fill out Parts 7 and 8. And this is about your monthly expenses. So your housing expenses on a monthly basis, utilities and food, you'll want to be as accurate as possible with these numbers, okay? So you may need to do some digging into your bank statements, credit card statements, and add up what you're actually spending to get accurate numbers here. Any expenses that you incur that you don't incur every month, you can do what's called prorate those expenses. So take the amount you paid during 1 year for that particular expense and then divide it by 12. And that's the amount that you would put in. Clothing, transportation, or automobile expenses, miscellaneous, and then you'll add all of those categories up. You'll also put in the debts that you pay each month. You'll list all of your creditors out and fill out all this information. And then this is the final page to complete about how you're providing the other copy with the side of the, or how you're providing the other side with a copy of this and filing it with the court. All right, that is the affidavit of financial information. And then the final document you need to file with the court to initiate this simplified child support modification procedure is a proposed child support order. Again, go into the Win Without Law School members area to the divorce or custody establishment sections and go to the child support strategy creation videos, and you'll find out exactly how to create a child support order. And you'll also get access to the Excel spreadsheet that will create this for you. When you are creating your worksheet, you can create the order and all of this stuff will auto-populate with the information you put into the worksheet. Overall, this is what the child support order looks like. Of course, it'll need to be completed before you file it. And there's a page 2 and a page 3. So that will be the final document you'll file to initiate your case. So just as a summary, when you're going, if you want to initiate a simplified child support modification case, you're going to file the petition, the request for hearing form, your proposed child support worksheet plus documentation supporting the incomes you used in the calculator or explaining why income should be attributed. You're going to file a completed affidavit of financial information and a proposed child support order. How do you serve the petition and related documents on your co-parent? You've got 3 service options. Number 1, you can do what's called an acceptance of service. Under this type of option, you hand deliver a copy of your 5 pleadings to the opposing party, and then the opposing party signs a form called acceptance of service before a notary public. So logistically, this can be a bit difficult because you've got to get in front of a notary or a court clerk to get this signed. So it takes a lot of cooperation, but it's a great option if you do have cooperation with the other side. Number 2, you can seek to serve your co-parent using certified mail restricted delivery. So you would put together, you'd get a copy of each of the 5 documents you filed to initiate your case, and then you'd put those into a big envelope and mail them to the opposing party via certified mail restricted delivery. Restricted delivery means only the opposing party can sign the green card. The opposing party must sign the green card for this type of service to be valid. Once you have the signed green card, you would complete and e-file a document called Affidavit of Service with Signature Confirmation. And then that would show service by certified mail. Finally, you can hire a process server. That's going to be more expensive than the acceptance of service or certified mail. However, that may be your best and most efficient option. Once the opposing party is served, you must file a proof of service with the court. So the proof of service for the acceptance of service would be e-filing that acceptance of service form. The proof of service for the certified mail would be e-filing the affidavit of service with signature confirmation. And then the proof of service for the process server would be an affidavit of service from the process server. And service is deemed complete upon the e-filing of the proof of service. So although the process server may serve the papers on, for example, February 1st, if the affidavit of service is e-filed on February 3rd, then February 3rd is the date the court starts the clock, looking at when service is done. Same thing with the acceptance of service. It's not the date it's signed, it's the date it's filed. Same with the affidavit of service with signature confirmation. So with the proof of service, the acceptance of service, you served your co-parent by having your co-parent sign the acceptance of service before a notary, then you're going to e-file the signed and completed acceptance of service form. For the certified mail, you served your co-parent via certified mail, then you're going to e-file the affidavit of service with signature confirmation. It's also known as a proof of service by certified mail. You may see it called that as well. And you'll include a copy of the signed green card and your receipt of the certified mailing as part of your filing. And then for the process server, if you had a process server serve your co-parent, then make sure the process server e-files an affidavit of service with the court. All right. Now, if you've been served with a petition to modify child support using the simplified procedure, how do you contest the petition? So if the parent being served disputes the requested modification, that parent must request a hearing within 20 days if they were served in Arizona, or within 30 days if they were served outside of Arizona. So the parent requesting the hearing would fill out and e-file that request for hearing form. And that request for hearing form, they need to serve on the other side via mail, no less than 10 business days before the hearing. So they'll need to serve the other side with their written request, along with a completed and sworn child support worksheet. So what will happen is you serve the papers on your co-parent. If your co-parent files a request for a hearing, they need to provide you with a copy for that request. And then the court's going to set a hearing date, provide you both with notice, and at least 10 business days before the hearing, the other side needs to provide you with a copy of their completed and sworn child support worksheet. So what they want the child support amount to be, they'll need to provide that to you no less than 10 business days before the hearing. So here's this form, the request for hearing. So if you've been served with the petition to modify child support using the simplified process and you want a hearing on it, then you need to fill out this form and file it with the court within 20 days of service if you were served in Arizona, or within 30 days of service if you were served outside of Arizona. You need to mail a copy of this filed form to the opposing party, and then the court will set a hearing date. And then with 10 business days prior to the hearing date, you need to provide the other side with a copy of your proposed child support worksheet. This is the party contesting the proposed modification. And so this is the child support worksheet. Of course, it would need to be completed and filled out, but this is what the form looks like. Now, what happens if the petition to modify child support using the simplified procedure is not contested? So your co-parent does not file the request for hearing form. If your co-parent does not request a hearing within the time allowed, then the judge will review the proof of service and the request for modification and will either grant the request, or they could deny the request and set the matter for a hearing. So if your paperwork is so rock solid that your request for modification is fully supported and crystal clear and the other side does not challenge it, then most likely the judge will just grant it and put the new order into place. If, however, your paper has some holes in it and the judge has some questions, then the judge will likely set a hearing. And notice will be provided to both sides of the hearing. All right, let's do a summary of what we covered today. First of all, if you're wanting to modify child support, figure out if you qualify to use this simplified procedure. Is there a 15% change between the current amount of support and what you want it to be? Do you want something changed about medical insurance coverage for your children? Do you want one parent to be ordered to provide medical insurance? Or do you want the parent that's currently ordered to provide medical insurance? Do you want that order changed? Or do you have a child that's now an adult and you need to change the child support order because you should be paying less because one of your children aged out? So if you qualify, then you're going to complete an e-file, the petition, notice, child support worksheet, along with your supporting income documentation, your affidavit of financial information, and your child support order. So it's the petition to modify child support using the simplified procedure. It's, that notice is the request for hearing form. So you're providing the other side with notice that this is how they can request a hearing. It's your proposed child support worksheet with the new amount you want the court to order, along with evidence supporting the gross incomes you used in your proposed worksheet, your affidavit of financial information, and your proposed child support order. You're going to serve your co-parent, and once they're served, you'll docket their objection deadline. So you can serve them by the acceptance of service, certified mail restricted delivery, or a process server. And if they're served in Arizona, then they have 20 days to object. So once they're served and you've filed your proof of service, if you serve them with Arizona, calendar 20 days as their last day to request a hearing. If you serve them outside of Arizona, then from the day you filed your proof of service, calendar 30 days as the final day for your co-parent to request a hearing. Now, for more information on service, if you can't find your co-parent, if you're having trouble serving them, go to the divorce or the custody establishment sections in Win Without Law School and go to the case initiation service of process videos, and you can get more information that will apply in this context as well. To contest the petition, so you've been served with a petition to modify child support using the simplified procedure. And if you want to contest that request, then you're going to e-file the request for a hearing form along with your proposed child support worksheet. If the petition is uncontested, so the other side does not request a hearing, then the judge is going to review everything that you filed to initiate your case, and then is either going to grant the request based on the pleadings and enter the new child support amount, or the court will set a hearing to get more information, or could potentially just deny it if your pleadings aren't sufficient. But overall, if it's not contested, then the judge will make a decision. All right, if you have any questions, please bring those to our live Q&A session. Thank you so much for joining me today, and I hope this was helpful.